hard is it to modify a custody agreement? Well, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. Is it tough to modify a custody agreement? I would say, without consent, that it is a difficult thing, and here's the reason why. You see, the main thing that the court is concerned about with respect to kids is stability. You know, there are a dozen custody factors, but they're all designed in a way to figure out where the kids would best thrive, with mom or dad. Now, what does best thrive mean? Well, it probably means where do they have the most stability? Where do they have the least volatile situation? What situation gives them the best opportunity to thrive in terms of home, in terms of social life, in terms of school? Which is it? So the court is very concerned about stability. Therefore, once the court makes a decision about custody, the court is loath to modify that without some very, very significant change in the circumstance that would force the court to reevaluate its very order. Now, if the order is brand new, we see this a lot of time. The court will conduct a trial, give an order, and a month later somebody wants to modify it. The court's not likely to react to that. The court will probably say, look, we just started this arrangement. Let's give it a chance to work before you claim that it's a failure. That's one thing. But if it's an order that's been around for a while, they've been following it for a couple of years, and now they want to modify it, well, the court has two questions it has to answer. Number one, is there a significant change in circumstance? If there's no significant change in circumstance, but it's just been this way for 2 years and now the other person wants more time, that is not going to cut it. The court may not view that as enough of a change to modify the painstaking effort that it went through to get the first order. The court's going to look at, is there a significant change in circumstances? Not just a change, but a significant change. And for example, significant change doesn't mean, well, the kid's older now. That doesn't mean anything. The court well realizes that time will continue to go on and turn, even though the judgment is finished. The court realizes that the kids will age. All of that is taken into account when the court enters its order. So that's not going to cut it. So number one, you've got to show the court that there's a significant change in circumstance. Let's say, for example, the kid is suddenly failing out of school. There's a significant change in the health of the child. There's a medical issue or something like that. God forbid the child gets debilitated and only one parent is really in position work-wise to be home with the child all the time. These are reasons why that may change. But notice what that's about. It's not about the parent having a change of heart. It's about something significant happening. And that significant change is enough for the court to revisit the issue. It doesn't mean that the court will change it. Many times, the court will find that there's enough of a change to consider revisiting and changing the custody, but it still doesn't change it. It still feels that it's in the best interest of the child to stay, despite the significant change. You see, even if they find a change, it doesn't necessarily mean that it's in the best interest of the child to move over from one parent to another. So there's two things that the court has to find. Number one, a significant change. Number two, that it's in the best interest to make a change. So the court could easily find one without the other. In other words, every case is going to be different. And in every case, we're going to have a situation where an analysis has to occur. Custody cases, change of custody cases, those cases are very expensive. You know from the get-go. You're going to call a lawyer about this, going to say, oh, change custody cases. You're going to have to bring a bag of money into some lawyer. So before you do that, talk to your lawyer and ask him or her, look, this is what happened. This is the change that I want to bring before the court. Is it going to resonate with the judge? Is it likely that the court will view that as a significant change in circumstance to at least reconsider? Your lawyer may say yes. Your lawyer may say no. Your lawyer may say, look, it's not something that we should bring in the form of a change of custody, but it might be something that we should file a motion and tell the court that they're violating this, bring it to the court's attention, so that if it happens again, or maybe 2 times, at that point we can say, Judge, enough's enough. We can't tolerate this anymore. You got to change custody. So sometimes it's enough to justify an immediate change. Sometimes it's not, and you have more of a long game going on where you lay a foundation for a custody change which you may file in a year. Later on down the road, once there's been multiple breaches of the agreement. Every case is different, so if you have any questions about yours, reach out, and we'll be glad to help you out.